All right, welcome to This Explainer. Today, we're diving straight into the Code of Civil Procedure, 1908. Now, if you've ever glanced at this absolute brick of a legal document, you know it can look incredibly intimidating. But don't worry, we're going to take this giant rulebook and turn it into a clear, easy-to-read map. We're breaking the whole thing down in simple English so you can understand exactly how civil law operates in India.
So picture this. You're caught in a bitter property dispute, or maybe someone just breached a major business contract with you. You know you need to take legal action, right? But ever wonder how a civil court actually works to find the truth? It's not just some judge banging a gavel and demanding answers like you see on TV. No, there's a highly structured, systematic process that courts have to follow to make sure everything is fair and transparent. And that exact process, that's what we're unpacking today.
Here's our roadmap for This Explainer. First, demystifying the CPC. 2. Cracking the code. 3. Phase 1, initiation. 4. Phase 2, the trial. 5. Phase 3, resolution. And finally, number 6, appeals and final thoughts.
Section 1. Demystifying the CPC.
Okay, before we get lost in the weeds here, we really need to address the foundation. What does this massive rulebook actually do for people in civil disputes? And honestly, what does it not do? The absolute crucial point to remember is that this code doesn't actually invent your legal rights. Like, it doesn't state your right to own a specific piece of land. That's what we call a substantive right. Instead, the CPC provides the essential machinery to enforce those rights. So if your land is taken, the CPC acts as the court's instruction manual to manage the fight fairly, efficiently, and totally in accordance with the principles of natural justice.
And you know, this modern code didn't just appear out of thin air overnight. The Legislative Council of India first enacted a code way back in 1859, just to bring some uniformity to civil procedure. But, well, it had some pretty major gaps. So it went through a big revision in 1877, another one in 1882, and finally, to meet all the challenges of a modernizing society, the 1908 Code was enacted. Literally decades of refinement went into building a procedural blueprint strong enough to stand the test of time.
Moving on to Section 2, Cracking the Code.
Now, a lot of people, even law students actually, get completely lost in the legalese of the CPC simply because they don't know where to look. So let's figure out how to read this map. The code is actually perfectly split into two distinct parts. On one side, we have the sections. There are 158 of these, and they act as the foundational backbone. They set up the jurisdiction, the powers, and the general principles of civil courts. On the other side, we have the orders and rules. There are 51 orders, and these serve as your literal step-by-step instruction manual. Think of it this way. While a section might tell you that a court can do something, the orders and rules tell you exactly how that stage is actually carried out.
All right, so we know this structure on paper, but how does this actually play out? How do these rigid sections and rules translate into the journey of a real-world lawsuit?
Let's dive into Section 3, Phase 1, Initiation.
Every journey's got to start somewhere, right? In civil law, this is where the dispute officially enters the system. And it all kicks off with something called the plaint. In simple English, the plaint is just the foundation of your case. It's the formal written document presented by the person suing. That's the plaintiff. In this document, you lay out the facts of what happened, who you're suing, and, most importantly, the relief you want the court to grant you. Are you asking for money? An injunction? Maybe you just want your property back. That all goes in the plaint.
But hold on a second. Before a judge is even allowed to look at your plaint, the court has to pass a really strict gatekeeper test. They have to have jurisdiction, which simply means the actual legal authority to hear your specific case. This involves 3 big checks. First, territorial jurisdiction, making sure you're in the right geographic location. Second, pecuniary jurisdiction, which ensures the monetary value of your suit actually fits within that court's financial limits. And third, subject matter jurisdiction, meaning this specific court is legally permitted to handle the topic of your dispute. If literally any of these are missing, your suit is getting returned or dismissed right out of the gate.
So, assuming the court does have jurisdiction, the initiation flows logically right through these steps. First, you file the plaint. Next, the court issues a formal summons to the defendant. This is an official notice, sometimes handed to them personally or sent via registered post, telling the defendant, hey, you are being sued, and demanding they show up. And finally, the defendant actually gets their chance to respond to the whole thing.
And in the CPC, that formal response is known as the written statement. Once they get that summons, the defendant usually has 30 days, though that can sometimes be extended up to 90 days, to file this document. In their written statement, the defendant has to address every single allegation made in the plaint. No skipping anything.
They have to specifically admit or deny the claims. And this is exactly where they set up their side of the story, or maybe even throw a counterclaim right back at the plaintiff.
Which brings us to Section 4, Phase 2, the trial.
Okay, so the paperwork is filed, the claims are made, the lines are drawn in the sand. Now we actually enter the courtroom for the trial. Now, if you watch movies, you'd think trials are just chaotic shouting matches with surprise witnesses bursting through the doors. But under the CPC, not even close. The trial progresses through these very exact, orderly steps to make sure it's a methodical search for the truth. It moves from the framing of issues, right into the plaintiff's evidence, then the defendant's evidence, and finally wraps up with closing arguments. So, it all starts with the court framing the issues. Honestly, this is a brilliant step. The judge looks at the plaint, looks at the written statement, finds exactly where these two parties actually disagree, and translates those disagreements into specific questions of fact or law. Those questions are the issues. And framing them officially marks the start of the trial. From there, the plaintiff presents their evidence first because the burden of proof is on them, and then comes the defendant's rebuttal. After all the documents are in and witness testimonies are recorded, both sides get to present their final arguments.
All right, Section 5, Phase 3, Resolution.
After both sides have presented every piece of evidence and really poured their hearts into those final arguments, the trial concludes. Now, the judge has to make a decision. When the court decides who wins and who loses, they issue what's called a decree. This is the finish line, guys. The decree is the formal, legally binding document that conclusively determines the rights and liabilities of absolutely everyone involved in that specific dispute.
Now, you'll often see people confusing a judgment and a decree, but let's keep it super simple. Just look at this comparison. The judgment is essentially the detailed essay. It's got the judge's reasoning, their findings on those framed issues we talked about, and the solid grounds for their decision. It explains exactly why the judge ruled a certain way. The decree, on the flip side, is just a short, formal ruling on what the decision actually is. It's the final, operative part that plainly says who gets what.
But of course, a victory on paper is completely useless if the loser just folds their arms and says, "Nope, not paying," or refuses to hand over the keys. That is exactly why the CPC has extensive rules for execution. This is the physical enforcement of the decree. If you win and the other party decides to just ignore the court, the CPC gives the court the power to enforce the order. They can attach and sell the loser's property, physically deliver possession of an asset to you, or, in some extreme cases, even arrest the defaulting party.
And that leads us into Section 6, Appeals and Final Thoughts.
So, what happens if the trial is over, the decree is issued, and you firmly believe the court made a massive, fundamental mistake in its judgment? Well, the drafters of the code completely anticipated human error. They baked in these vital post-judgment remedies just to make sure bad rulings can actually be challenged. You can file an appeal to take your case up to a higher court, like jumping from a district court up to a high court. If you suddenly discover crucial new evidence that wasn't available during the trial, you can ask for a review. And if the lower court just totally overstepped its jurisdictional bounds, the high court can step in and fix it through a process called revision.
Ultimately, the Code of Civil Procedure is highly rigid, deeply structured, and, yeah, occasionally quite complex for this exact reason. It's not just about ending a dispute, it ensures that fairness is visible to everyone involved, leaving literally zero room for doubt or arbitrariness in the eyes of the law. Every single section, every single rule exists to guarantee a fair fight. But it does leave us with a fascinating question to ponder. In our pursuit of a perfectly structured legal system, do these super rigid procedures ultimately guarantee justice, or do they just guarantee a process? Think about that. Thank you so much for joining me for this explainer. I really hope you now see the CPC not as a barrier, but as a fascinating map to the truth.